Hello and welcome to the Inverted Chaos Podcast. My name is Luis Hurtado. We have a great podcast for you today. My guest today is Don Dennis, and we're going to be talking about if it's possible to protect your website designs. You spend all this time coming up with your website, but can you legally protect it? I'm your host, a multidisciplinary graphic designer and animator living in Los Angeles, specializing in creating user interfaces for mobile, web, and motion graphics for television and advertising. Previously, I have been a visual design lead at several of the top agencies, television networks, and game studios, including NBC Universal, Hulu, and True TV. Don Dennis is a Los Angeles-based attorney that specializes in internet law and intellectual property. He assists clients of all sizes, from startup companies to established corporations. Attorney Dennis is also a professor of law and enjoys explaining the law in plain English. Attorney Dennis obtained his Bachelor's of Science in Civil Engineering from Northwestern University and his Juris Doctor of Law from UCLA. So this topic has come up in the past with me specifically, but I'm sure it's something that a lot of people have mulled over, whether you can create a copyright for your actual website, or if that's something that's open source and out on the internet, and keeping with the way the internet is. It's like, if you put it out there, if it's not actual content, if it's just a website, are you able to create a copyright for that? Don, pleasure to have you on the show.
Thank you. It's a pleasure to be here.
Thanks. So just to get this started, if the content on my website is already under copyright, doesn't that mean that the website is also under copyright law?
Well, when you say the content is already under copyright, what exactly do you mean by that?
Meaning the text, the photos, the videos. If you were to copyright those specific forms of content,
Okay.
if that were on a website, would the website also encompass that as well?
No, not necessarily. And just a little disclaimer before we get started. I am an attorney. However, all the information I'm providing today is general information. And if you have any specific legal issues, you have to contact an attorney and form an attorney-client relationship with that attorney so that you can have one. Our information is just of a general nature. It should not be construed as specific advice for your situation. Now, with respect to what you asked me concerning being able to protect, and is the information already protected, the content that you have on there, it really depends. For example, first and foremost, did you in fact create that information that you put on the website? Did you take those pictures? Did you pay someone to provide you those pictures? Did the music that you uploaded to your website, were you the creator of the music? Do you own the rights to the lyrics and also the sound? And did you produce it? And then with respect to photos, did you take those photos? And also with respect to the typewritten content, is that your original creation? And so that's what, the Copyright Office looks at. Who is the original creator? And if you're not the original creator, do you in fact own the rights to the copyright for it?
Right. So there's this term called copyrightable authorship. Is that what you're referring to?
Yeah, that's what the Copyright Office looks at when they're making a decision as to whether or not you can be afforded or given a copyright, which is basically saying that you own the original creation. And what they're looking for is that you have, and I want to be specific, I don't want to mislead anyone, according to their office.
Mm-hmm.
They're looking to see if what you're claiming you have the copyright in is your original expression and it has a minimum degree of creativity. So what do I mean by that? Meaning that anyone can sing the song Jingle Bells, or anyone can sing the song Santa's Coming to Town. However, if you add something new to that, if you do it, for example, let's say it never had been done in a rap version, and you do it in a rap version, you change up the lyrics, you change up the beats a little bit, then you've added more to it. You've transformed the song, and that's what they're looking for. So the
Hmm.
fact that you've made more out of it, you're not just copying it and singing it the same way, you may be able to get copyright authorship in it and secure a copyright for your version of how you expressed the song.
Right. So, um, is there a catch-all copyright for the entire basis of my site, or would I have to individually copyright each blog post, for example, if I were creating a blog?
Well, their copyright office does allow the copyright of a collective work or a compilation. So, for example, if the selection, the coordination, and the arrangement of the content on your website is original, then you can seek to copyright that layout. However, just putting out a website in general, you can't get a copyright for. So you have to be careful with that. But if all of the content on there, and let's be specific about content, if you own all the photos
Hmm.
outright, then yes, you can secure a copyright for that. If you own all of the music that's on there, you can secure a copyright for that. And if you own all of the written wording, you can secure a copyright for that. So, for example, specifically, you would secure a copyright for the text if it was a blog as a literary work. You would
Hmm.
secure a copyright for the music as a performing arts work. And then you would secure a copyright for the photos as a visual work. However, as we know, websites change because
Hmm.
people are always updating them. So that would be the copyright you had at that point in time. Once it changes, you would have to revisit and redo the process all over again. So sometimes it can kind of be a futile exercise to go through all of this.
Right.
However, if you're talking about protecting it, another idea that you could consider is maybe protecting your website domain name.
Mm.
Because protecting that domain name, then you kind of, because your domain name is what you're using to brand yourself anyway, right?
Hmm.
Like if you think Google, that's what people think of. Oh, Google, type in Google. And Google wouldn't want a bunch of knockoffs or other people trying to use that name. So you could look into, if you're selling a business, selling a good, or you're providing a service, just trademarking that domain name. And then
Hmm.
that would give you protection for that name itself, will give you protection as a trademark for the website, for hashtags, for Instagram, for Twitter, things of that nature. So if anyone tried to use it, they'd be blocked.
So if you were to trademark, let's say you're starting a company or a brand, and you start a corporation, and you try to trademark the mark of that corporation, would that also include the domain name, or is that a complete separate copyright?
No, no, no. Now we're talking about something different. We're not on copyright, but that trademark would protect it in however you use it.
Mm.
So whether you used it just by trade, for example, if we're talking about Google,
Hmm.
trademarking the name Google would protect it. Whether you use it for the domain name, whether you use it for
Mm.
your username or what have you, it would preclude others,
Hmm.
meaning it was going to prevent others. And if they do use it, you could sue them for infringement.
Mm. Cool. So this is the initial topic that we were talking about at the top of the show. What can you copyright the visual design of a website?
Well, it gets a little complicated because you have to be sure that you own all of the content, and you cannot copyright, the specific elements. I'm sorry, you cannot cover, or we talked about, you can't protect the general layout
Hmm.
or the format of web pages. So you have a home page, you have a contact page, you have a services you offer, a products page. You can't copyright that layout, but the compilation of how you lay it all out,
Hmm.
provided that you own everything, you may be able to seek protection for that.
So
But once you change any word on it, you have to get a whole nother copyright.
I see. So you can't copyright like colors and branding. You know how what's a good example? Verizon has the red, the red and black. Like you Boost Mobile has got that orange. That those are like branding techniques. What is that something that can you copyright that on a website?
You would want to trademark that.
I see.
And then once you trademark that, because when you trademark something, you're protecting your idea in terms of your logo. And you're referring, I believe, to a logo.
Correct.
So so that would be a design mark, because that's the design that Verizon, under the situation that you gave, wants affiliated with them. So you would get a design mark, trademark, and then that would protect it being used in whatever media they want to use it in. So if someone snatches it and places it on their Instagram page and says, "Hey, look, even Verizon loves me," Verizon can, go against that person or sue them for infringing on their brand.
So if you were using like an off-the-shelf WordPress theme and you altered it to create like a choose your own adventure kind of website where it's like the text is a original what do they call it, original piece of work, is that, you started off with something that's off the shelf that everybody has, but then you use it in a very specific sense, where does the line drawn there?
So to be honest with you, copyright law is very tricky. And in fact, the Supreme Court, in one of their decisions, said that this is one of the most complicated areas of law. So what they do is, when a court is first of all, let's back up. When you're talking about whether or not you did something that was fair, well, let's back up even further. Say you have an idea and you want to get it copyrighted. All you have to do is fill out the application, pay $35, $40, something like that, and mail it to the Copyright Office. They're not going to do an exhaustive check to see if you're infringing on someone else's idea. They're just going to end up registering it. The issue comes up if someone feels you've infringed and they commence a lawsuit, or they send you a letter from an attorney telling you to stop using this. So what we're talking about is analyzing situations so you don't find yourself in a situation where someone has accused you of infringing. So we're trying to prevent all of that. So the way a court examines the matter is called the fair use test, in which they examine, to distill it, the bottom line is, have you transformed the work? Are you copying and using it exactly the way it was presented to you, or have you transformed it, made significant changes where it's not identical? It doesn't have to, where it's not similar. It doesn't have to be identical. They're looking to see, if it's identical, that's an easy, hey, you used our stuff, you didn't own it. But how significant of changes did you make to it? And so with respect to that WordPress website, one of the things you want to look at is in the agreement. For example, you want to consider, are they saying, hey, you're using this and you have the right to obtain intellectual property ownership rights in the content, or are they saying you can use it at your disposal, but retain the rights of ownership?
Right.
So if they retain it, it would be futile for you to do it, or you're looking at a potential problem. Whereas if they say, hey, it's yours, you own it, then, it would seem that, you might want to begin looking into how far you can go with it. But you have to be careful, and you have to pay attention to that kind of stuff, because you don't want to waste time and effort trying to register and protect something that you're not going to win in the end.
Right. So just let's back up, and this is kind of a very basic question for me as well. In terms of copyright law, just because you copyright something, like, you also have to enforce your own copyright, correct? Like, you have to go around and see if someone has infringed upon. The government isn't going to go around and find these people for you, right?
That's correct. You are responsible for policing your trademarks, policing your copyright, policing your patents, any of your ideas. You're responsible for it. And like you said, you can't call the police if someone steals your ideas. The police are not going to show up, police report, and say, hey, okay, we're going to go arrest this person. It doesn't work like that. And then second of all, even if someone is infringing on your ideas, it may take you 2 years to get into court. So unless you're filing some type of emergency injunctions to stop them immediately from doing certain things, or you're contacting the International Trade Commission and stopping the import of items at the port, or train station, or the shipyards, or things of that nature, or the airport, So, in the meantime, what are you doing if someone's stealing your idea? You have to, that's why you want to police it, in advance and put certain precautions in place. But no, you have to police it yourself. And then
Hmm.
also, you have to think about, if someone is infringing, is it worth it for you to go after the person? Because you could spend easily, a couple $100,000 in court, and then, to sue someone for infringing, and according to the law, they owe you $1 million. But if they're working out of their garage, and don't have any money, then what?
Right.
You're right, but you just got a moral victory and a
Right.
paper judgment.
That's a good point. So this is fairly typical for people who. What if I hire a programmer as an independent contractor to create the website for me? Who would be the author then?
Well, it all depends on what type of contract you have. For example, as the Copyright Office says, was it a work for hire, meaning that you have an agreement with the independent contractor that says whatever you create, it's a work that I paid you to create and I hired you to do this, and therefore I own it.
Hmm.
Because otherwise, it leaves to question who owns it. And the copyright and the creator, the independent contractor, can register a copyright and say, I own it. And I just gave you a license to use it. Just like when you rent a car, you have the right to get on the freeway and drive from LA to Vegas. But at the end of the day, you still have to return that car. You just had a permission to use it temporarily, but
Hmm.
you don't own it. You can't go tint the windows, and you can't, change the rims on the car and put music in it. It's only certain things you can do with it. So
Right.
it's all down to the agreement. So the same way a rental car company will have you sign pages and pages with all that fine print of an agreement to rent a car for the weekend that's only 34 or $50 a day. Your ideas are worth a lot more. So if they're that careful about a rental car, you have to really consider, what kind of agreement are you giving people, or are you making with people concerning your ideas?
Right. So that's a very good point. Like, it's everyone out there who is just kind of like flying by night, or just hiring some guy off Craigslist or Fiverr or something like that. You really want to make sure that you work with a lawyer on creating these agreements that are going to cover you for what you want to create out there. Can't just be like hiring people and expecting this that you're going to own everything, because if there is no agreement in place, they created the website, so they are still the owners of that authorship, correct?
Well, it's not that simple, but again, the only way that that would get sorted out, to find out who, in fact, would be deemed the true legal owner, would be to go before a judge.
Hmm.
And you're
I
not going
see.
to get before a judge unless you're paying a lot of court fees and cost, and then waiting and delay and all that time. So instead of spending time focusing on content creation and having just peace of mind, you're inundated with paperwork and just sitting down watching the clock. So it's like watching grass grow. Sitting in the rainbow, sitting in the rain, waiting on the rainbow, hoping things get better.
Yeah, yeah. So it's like you just want to make sure you cover yourself early on, and just nip all this stuff in the butt
Yep.
before creating this whole hassle.
Hmm.
Yeah, that makes sense. All right. So what if the website that I'm attempting to copyright has a large amount of user generated content?
Again, so user generated content is just that, a user, meaning like a viewer or a browser or some person somewhere from here all over the world. You visited your website, and maybe they inserted comments, they uploaded pictures, they uploaded music or what have you.
Hmm.
And now we're talking about, can we get protection over our website because it includes elements, music, video, photos, that we didn't text, that we didn't create. And again, going back to your original question, when we talked about what can be protected, we were talking about original expression. Well, clearly, this is not your original expression because a user generated the content. So, in order to be able to begin the process of trying to secure copyright protection for a website that includes someone else's content or information, it goes back to what your terms of service agreement is.
Mm.
Terms of service is something, or terms of use, is basically that little link on the bottom of a website that most people ignore. But it's, in other words, in the most simplest words, it's a contract. And it's the contract or agreement that you make between you and the people that go to your website, determining who owns what, how you govern things, and how transactions will be handled on your website. So, as the Copyright Office had stated, it'd be important to delineate in very clear terms what content that is uploaded or placed onto your website you own, and what content that is uploaded or placed on your website by a user they retain rights to.
Mm-hmm.
If you retain rights to them, then you are the owner, and therefore you possibly can move towards getting that copyrighted. But if it's unclear or if it's vague, that places you in, a nebulous area where you're taking risk that could cost you money.
Cool. So just to wrap this up, I've just a couple more questions, and we'll send you along your way. Does placing a piece of work online signify that it has been published by the Copyright Office?
Not necessarily. The Copyright Office, in order to be published, an item, and they have specific definitions for what they deem published, because a copyright work has to be published in order for it to, be afforded protection.
Mm-hmm.
So just posting it without, first of all, you have to have authority. So if you're the original creator of it, that's the first and foremost check mark that we have to check off. Now, when you post it, is there something that says anybody that sees it can download it and it's authorized? If so, that means it's been published. Is it available? You have a subscript or a text that says it's available in electronic or a physical format for other people, which is tangible, something real, like a DVD, a CD, then that means it's published. If you put something online, like you go to the Los Angeles Times website, and you can get a copy of those same articles in the newspaper, and they can be downloaded or printed, that means they've been published. So that's what we're talking about with published. But if you have something up there and it says you can't download it, that's prohibited, or you can't make copies of this without permission, that does not constitute an item being published. So something has to be, that's what we're talking about when we're saying published.
Right. So if you were to stream something live through YouTube or Twitch or even Facebook Live, that since there is no way you can download that piece of content afterwards, that would not be considered published, correct?
That's correct. It would not be considered published because the user or the viewer doesn't retain a copy of the work when the streaming ends. Right.
Great. Thanks, Don. This is super informative. I think everybody out there is gonna they've been enlightened through this very complex form of law, really, one of them. So I really thank you for being on the show. Thank you so much, Don.
Thank you. I appreciate it. Thank you for the opportunity. And if anyone has any further questions, feel free to visit my website at dondennislaw.com.
Yeah, so please contact him at dondennislaw.com. I'll have the link in the description, and along with his social accounts, so that you're able to contact him directly. Thanks, Don.
Thank you.